Good evening, everybody, and welcome. My name is Rhonda Rosen, and I am the Programming and Exhibitions Librarian here at Hannon Library. On behalf of our entire outreach team, welcome to Virtual Faculty Pub Night. Tonight's Faculty Pub Night speaker will feature Jennifer Rothman, Professor of Law at LMU Loyola Law School here in Los Angeles. Professor Rothman will be discussing her fascinating and timely book, The Right of Publicity, Privacy Reimagined for a Public World. However, before we begin, I would like to remind you all that Faculty Pub Night is the library's opportunity to spotlight our faculty's accomplishments for our students, staff, faculty, and during COVID to anyone who has Zoom. So please spread the word. Ground rules for tonight. We will be recording this evening's presentation and it will be available on the library's YouTube channel. After Professor Rothman's presentation, I will introduce Roseanne Korenberg, Clinical Assistant Professor of Film in LMU's School of Film and Television, for a one-on-one conversation with Dr. Rothman. After that, we will open it up to questions from the audience. And remember, if you have a question for either of our speakers during the presentation, you're welcome to submit it by using the Q&A function on the bottom of your screen. All questions will be compiled by our outreach team and submitted to our speakers as time permits. So let's move on for our evening's event. Jennifer Rothman is the William G. Cosgran Chair and Professor of Law at LMU Law School, Loyola Law School in Los Angeles. In the spring of 2021, she will be a visiting professor at the University of Pennsylvania School of Law. Jennifer Rothman is an elected member of the American Law Institute and an advisor on the Restatement of the Law, Third, of Torts, Defamation, and Privacy Project. She is also an affiliated fellow at the Yale Information Society Project at Yale Law School. Ms. Rothman is the author of The Right of Publicity, Privacy Reimagined for a Public World, published by Harvard University Press, 2018. Her most recent article, The First Amendment and the Rights of Publicity, was just published in the Yale Law Journal. She is also the 2019-2020 recipient of the David P. Leonard Faculty Service Award for Outstanding Teaching and Service. So let's welcome Professor Jennifer Rothman.
Thank you. Hi, everyone. And thank you for that lovely introduction and for inviting me to talk about my book. I wish we were all together in a physical pub night so we could cheer and have snacks together and mingle and I could actually see you. But I hope that I will at least provide some sustenance of thought, if not literal food or beverages. So I know we're going to have a really wonderful conversation after this introduction, but I thought I would start by talking a little bit about what I wanted to accomplish with this book project and an overview, particularly of the historical aspect of the book, because some of the more contemporary issues that the book raises, I hope will flesh out in conversation. So the origin of this project was to challenge a conventional story that turns out to be incorrect about the right of publicity and its development in US law. And part of this is driven just by my scholarly interest in truth finding and wanting to correct essentially a 70-year narrative that was wrong. But by doing so, I had some additional objectives. And those objectives were that by revisiting the origin story of the right of publicity, it would lend guidance to how to address some of the worst aspects of today's right of publicity law, from the danger of losing ownership over your own identity. In other words, someone else could be the owner of your name and likeness and other aspects of your identity, to the ability of the right of publicity to shut down free speech and expression, or to interfere with the exercise of the copyrights of filmmakers and other creators, photographers. And we may talk more about some of those issues in a bit. At the same time, I thought that by revisiting the origin story of the right of publicity and its long-standing connection and harmony with the right of privacy, it would lend some guidance for how to solve some problems that the right of privacy and privacy law itself is failing to address in our modern, particularly our digital age. So that was the motivation for this project. And I know that we have a diverse audience this evening. Not all of you are lawyers or law professors. In fact, most of you, I suspect, are not, and that's okay. Don't worry. I'm going to try to get us all on a foundation for this discussion. Most importantly, I will at this point share my screen, which I have not thus done for our discussion. There we go. Okay, so I hope people can see it, and if not, I hope someone will text or send me a chat of some sort to tell me about it not being shared, but hopefully it is. And to get us on a level playing field here, I want to just define the right of publicity for people who are not familiar with it. It is a state-based legal right that gives each of us a right to stop unauthorized uses of our identities, most notably uses of our name or likeness without our permission, and usually for the defendant's advantage, and can be sometimes for the commercial advantage only, but could be for any advantage whatsoever. And as I said, this is a state law right, and that means it varies widely from state to state. And because of this, started a website called Rothman's Roadmap to the Right of Publicity, which you can go to, and you can actually click on different states and find out what the law is. And I also do updates on recent cases and issues. So I did that in part because, as I said, the law varies widely, but the broad definition covers the basis. So it gives you a right to stop others from using your identity without permission. So one thing that you may have heard, and privacy law scholars will hate my use of this slide, but I'll just say some of you may have heard this saying that privacy is dead. That privacy is dead. In our modern era, everything is done in public. People are filming us as we go about our business. They're sharing it online. And so there really is no longer a space that's secret or secluded. And although that has some inaccuracies about it as a broad statement of the law, it is nevertheless evocative of some failings in the way we conceive of privacy. To the extent that we think that privacy is abandoned when we're in public, when we share things, that we lose all control of them, is to miss one of the central insights of privacy law from its origin. And so part of the process of this project and its motivation was to reclaim a broader vision of the right of privacy that is encompassed in today's right of publicity. One that is not about whether it was secret or secluded, but that it is intimately tied to an individual, and we get some say in how our identity is used. So it's often said that the right of publicity and the right of privacy are opposite sides of a coin, that they are different from one another. It is sometimes said, though incorrectly, that the right of privacy is just about individual dignitary injuries, emotional harms to an individual, that it protects secrecy, it protects seclusion, and that the right of publicity is a claim for celebrities and only for economic or commercial value. This view, this long-standing view, turns out not to be true. And in fact, the right of privacy was much more capacious at its origin, and the right of publicity itself is much more capacious than just that narrow vision of being a cause of action for celebrities. In fact, what happened when these two rights became disentangled, as they sometimes are, is that the right of publicity became transferable, meaning that it could be treated like other intellectual property rights and taken away from the underlying individual, the underlying what I call identity holder, which should be concerning to us all. So part of this project is a deep dive based on some archival work I did into what I call the original right of publicity, which is really the right of privacy that originated in the mid to late 1800s into the early 1900s. And this original right of publicity, which created the right of privacy in this country, is very much what we think of as the right of publicity today. It is about these early famous cases. For those of you who follow these things, Roberson v. Rochester's up on the left, and Pavicic v. New England Life Insurance is on the right. Our typical right of publicity cases, they involved unauthorized uses of a person's image through their photograph that they'd actually, each of them had sat for, but then didn't agree to its use in advertising. Both of them sued. One of them unsuccessfully, Abigail Roberson, but then that led to New York passing a right of publicity statute, which remains in place today. And Paolo Pavicic won his lawsuit for these unauthorized uses, both to advertise flour and life insurance. Sometimes people think of these cases just as being about emotional injuries to these private figures. However, the right of privacy at this time was much broader than this, as we'll see in a minute, covered those who were also very famous celebrities with endorsement careers, even during this era. So a few things were going on at this time and that really helped shape this broader view of what the right of privacy was about. And there were a lot of technological changes at this time from the Industrial Revolution, including greater communication and transportation over great distances, creating a worldwide market in celebrities and endorsement careers. There were improvements in printing technology that allowed for an increase in the number of newspapers, magazines, and the publication of photographs. Of particular note was the development of the instantaneous camera, a portable camera that anyone can use that was easy for just a regular consumer to pick up and then snap shots of people walking down the street, and led to outcries, much like we have today with people worried that someone is live streaming them while they go about their daily business and then putting it up on the internet. The outrage in the mid to late 1800s was that you could be walking about your business thinking you were alone and someone would snap your picture. Up on the screen is a period advertisement for the Kodak camera, one of the first of these portable or detective cameras. One of my favorite advertisements of this era is a 1903 or 1904 advertisement for Fulmer & Swing's deceptive angle graphic camera. And if you look at the image, you can see that the man is pointing away from his subjects, the two women, while taking a picture behind him. And if you look even more carefully, you might note that there's the ocean in front of him, and that the two women are actually wearing, rather than fancy attire as it looks like today, but wearing bathing costumes. So it's particularly outrageous that that he's taking their picture without them knowing about it, wearing their bathing suits. And of course, this was their advertisement to encourage people to purchase it. Probably no wonder then that there was hundreds of articles, editorials in newspapers calling for a right to control publicity about oneself to prevent these unauthorized uses of photographs to sell newspapers and magazines during this era. And there's a few quotes of this time, starting in the 1880s, calling for this change. Now, privacy, as I said, sometimes you hear the story that the right of publicity needed to be created to protect celebrities or public figures and their economic damages. What my archival work shows is that this is not true. In fact, from the very beginning, the late 1800s on, state tort privacy laws did publicity's work. I document in the book numerous examples of famous performers who made privacy-based claims and succeeded. One of them, Mary Manola, all the way on the left, succeeded even though her complaint was that she was photographed while on stage performing at the time of the photograph. We have Fred Astaire bringing a claim for the use of his image in advertising. To his left is Charles Elliott, the president of Harvard University, who also brought a claim in the early 1900s, successfully also under privacy, as well as many other performers on the stage and radio. These figures were not just limited to personal injuries, they were also able to successfully recover for lost endorsement value. They were able to recover even if they had no claim of emotional harm or embarrassment or reputational injury from the uses, and even sometimes when they had already themselves circulated the images that were used even in advertisements. And in sort of my archival work, I also found various jury verdicts that allowed for the recovery of purely commercial economic damages through these privacy-based claims. So what was missing? Why did people think we needed this right of publicity? Now, for those of you who are not steeped in this, which may be many of you, you should just know that there is this story, this mythology that grew up that we needed a right of publicity, and that it was created in the year 1953, and that it was created to address the problem of these public figures being denied recovery and privacy law. But as I document in the book, this isn't true. What was really missing was transferability. That meant that the rights to one's own identity couldn't be transferred to a third party. And to the extent that we recognize something distinct from the right of privacy and the right of publicity, that is where its origin lies. The case that is frequently and erroneously credited with having created the right of publicity is the 1953 decision in Halen Labs v. Topps Chewing Gum, a Second Circuit case from 1953. This case involved baseball trading cards, and it's commonly described as the case that created the right for the baseball players to stop their names and likenesses from being used without permission. This is not what happened in this case. There were no baseball players who were litigants in this case. Instead, this was a lawsuit between the two major producers of chewing gum in the United States during this time. Both of them used baseball trading cards to increase their sales. Both of them knew that under then existing law, they needed to get the permission of the baseball players to include them in the cards. And both companies did get the players' permission, and the players were authorized both of these uses. So you might think this is an odd case to have purportedly created this right of publicity. What this case was really about is that the one company, the plaintiff, Halen Labs, was upset that the players had also given the other company permission to use their name and likeness on the cards. They claimed to have an exclusive right to the players' identities. Now, there were a number of ways in which Halen could have preserved a contractual right, both in tort law against the competitor, as well as in contract law against the players who may have breached a contractual agreement. But what Halen argued was that they should have a transferable right to the player's identity. That means they would have it, the players wouldn't, and then the players wouldn't have been able to transfer anything to the second comer company. And it could be enforced, this right, against the second comer, Topps, as if it were an intellectual property right like copyright or patent. Now, the machinations of this litigation is fascinating and revealing. I went through many boxes in archives in a basement in New York, one of the few of the court files to not be flooded. There was rotting gum in it, and it was quite revealing, largely about the twists and turns of the litigation in this case. And I recommend to you the chapters in the book that cover this fascinating story of how the right of publicity became relevant in this case, for which it really wasn't relevant, as it turns out. But I can't get into that here today because I'm trying to give a short overview. What I want to simply highlight with this case is that it was not about protecting the baseball players' individual interests, which were already clearly protected under the relevant New York law at the time. Instead, it raised the specter that perhaps there was a right in a person's identity that could be transferred away from that person. This language in the case was picked up by a studio lawyer, who some of you may be familiar with, Mel Nimmer, who went on to an illustrious career as a professor at UCLA. But at the time he picked up the suggestion from the Halen case, he was a lawyer at Paramount Pictures. And for those who follow the studio system and its demise, the studio system had largely collapsed in the 1940s. And so the studios were looking for new ways to control their stable of actors, and having them transfer the rights to their own identities looked like a pretty appealing opportunity in this regard. And so that was one of the suggestions of this famous article by Melville Nimmer. There were also a number of lawyers who thought it would be great if they could harness the value of individuals' life stories and identities for use in movies and the theater. One such lawyer was Harold Gordon, a well-known Chicago attorney, who thought maybe he could harness income for Al Capone's heirs or get money for Nathan Leopold by having this right of publicity that then he could authorize for others to use. A very broad and troubling from a free speech protection claim. But Broadway producers, movie producers, and those who represented individuals with high value life stories and identities thought this transferability might be particularly valuable. And that's sort of where things sat for decades until the summer of 1977. So after Halen, not much happened. There was a suggestion maybe there's something transferable, maybe there's something different from the right of privacy and this right of publicity, but the courts didn't really adopt it, states didn't adopt it. Then in the summer of 1977, Elvis Presley died. His manager, who had owned most of him while he was alive, wanted to continue his gravy train after his death and tried to claim there was this post-mortem right in Elvis's identity. That same summer, the US Supreme Court decided the case Zucchini v. Scripps Howard Broadcasting, right, in sort of the aftermath of Elvis's death. And this case involved a human cannonball artist who was shot out of a cannon, and his performance was 15 seconds in length. And the nightly news filmed him at a fair where he was performing, put the 15-second performance onto the nightly news as a clip, encouraging people to attend the fair. Hugo Zucchini, the performer, sued, claiming a violation under Ohio law of his right of privacy. This was converted in the mind of the Supreme Court to a right of publicity, which it distinguished for reasons from a right of privacy, and in particular from the false light tort for First Amendment purposes. Again, I go into the history more on this in the book, but just briefly speaking, the Supreme Court rejected a First Amendment defense by the news station to the use of the performance and turned the right of publicity into this intellectual property right, analogizing to copyright and patent laws, shoring up this view that the right could be transferable. Part of this was that 2 nights, based on my archival work in the Supreme Court files, 2 nights before oral arguments in this case, Justice Blackmun had gone to the symphony and had noted that you couldn't record these symphonies. The underlying music was not protected by copyright. And so he was concerned that uncopyrighted works that were performed could be filmed and then put out to the world in the guise of news without First Amendment protection, claiming to hide behind First Amendment protection if Zucchini lost his suit. And so there was this concern about uncopyrighted plays, right, who may have fallen into the public domain, but the live performance could be recorded, symphonies, as well as sporting events. And this really drove the Supreme Court's decision, even though it's pretty anomalous to have these performance cases. This set up a world in which the right of publicity became something distinct from the right of privacy, not because it now covered only celebrities or only protected economic or commercial rights, because as I document, those were all present from the beginning of the right of privacy. But what it did do is it created an opportunity or potentiality for the right to be transferred away from the underlying individuals, which I think is a very chilling prospect and one that I've argued should not be permissible as a constitutional matter. It also led to the right of publicity being expanding greatly and also being less limited or reined in by First Amendment and free speech interests, because generally speaking, intellectual property laws get a pass, not a complete pass, but certainly less scrutiny from a free speech perspective than other limits on speech. It also set up greater clashes with copyright law because of a more capacious understanding of the right of publicity, which has grown and grown, even including claims to persona, like that robot might remind people of me, and therefore you can't have that robot there with you. So this is sort of where my overview of the project ends. I go into some of these current problems and challenges for right of publicity law, as well as some of the opportunities that the right of publicity affords to deal with current issues, like Facebook using our images without permission to advertise, or monetizing our data, as well as how to address things like deep fakes in the book. But at this point, I want to stop and open the conversation to Rosie.
Wow, thank you so much, Jennifer. That was fabulous. And I think that you should get an honorary degree to be a librarian for all your archival work. Awesome. I love that. I wish I could have been there with you. I would love to be digging in those archives. So now let's introduce Roseanne Kornberg, who will do our conversation with Jennifer. So Roseanne Kornberg started her career as an entertainment lawyer, but fortunately for us, she is currently a producer and executive producer of film and television, as well as a clinical assistant professor of film at Loyola Marymount University. As an independent producer, Professor Kornberg has a track record of discovering new talent, and her film projects, including Hard Candy and Half Nelson, have premiered at Sundance and other major festivals and gone on to win or be nominated for Oscars, Spirit, and Gotham Awards, and the Humanitas Prize, among others. She recently served as the Senior VP at Miramax, where she supervised Mr. Holmes, Bridget Jones' Baby, South Side with You, Whitney, and the award-winning and my favorite, I, Tonya. She also oversaw a successful slate of film acquisitions and co-productions at 20th Century Fox, Fox Searchlight. In a more entrepreneurial vein, Roseanne set up the new media film division for Caviar Content, where she developed the series Replay for Gatorade, which won 8 Golden Lions and ran for several seasons on Fox. She also founded Traction Media, a sales repping company. So, welcome, Roseanne, and I'm going to let you take it away now.
Thank you, Rhonda, and Jennifer. So nice to have you here, and I found your book really fascinating, and I think I could be here all night asking questions, and we don't have that much time, but I did want to ask you briefly because, as Rhonda said, I went from practicing law to full-time production, and I read in your bio that you have an MFA and worked in production, then went to law school, and I'm just fascinated that you managed to combine the two. So, I mean, just because I know we have a lot of people in the audience from various schools, if you could just talk about that a little bit, that'd be great.
Great, thank you. And I'm so honored that you can join for this conversation. I'm not sure there's a better person, given the sorts of movies that you produce, to talk about the issues raised by my book and the Right of Publicity.
My next question, but I'm so curious about your jump, and I'm sure everybody listening is too.
Yeah, so I in some respects, the shift was somewhat mundane or uninspired in the sense that I wanted that I was somewhat frustrated in the film industry, both financially, I'll concede, not coming from a wealthy family, trying to generate sort of as a producer and writer funding to make things, which I'm sure you've overcome, but is a challenge. And then I was working for Paramount, and the projects didn't really speak to me. I felt like I could do more intellectually. And I think when I was little, everybody thought I would be a lawyer. And so in some respects, the detour was film. Although I love movies, but and then when I went to law school and I loved film school and making movies, it was very meaningful to me. I made an award-winning documentary, and won a DGA award and was written up in the LA Times and the LA Weekly for my film work. So I was having some successes, but I felt like there was just something that wasn't gelling, and I decided to go to law school because I figured I could do anything with it. I could go back and produce. I could become a scholar and a professor. I could practice law. There's so many things I could do. And then when I went to law school, I just loved the intellectual depth of engagement, and all those people who said you should be a lawyer. It spoke to me. And then I saw all these cases and started really focusing on intellectual property, and saw the intersection between creative production and the law, and felt like I was uniquely situated to be able to think about the law from the perspective of a creator. And then just sort of loved it and went the legal academic route.
Yeah, that's what I suspected, because your work obviously integrates a couple of passions of yours. So thanks for laying that out. That was what I thought you might say. I'm just going to dive into the last slide of your presentation because it's where my, say, passion and terror lies, which, as your last slide pointed out, is this growing, expanding right of publicity and its clash with the First Amendment and content creation. I saw in the press that you filed a brief in the Olivia de Havilland case. And for those who don't know that, Olivia de Havilland, who's since died, brought a lawsuit. I think she was, I don't know, in her 90s or 100 years old. She brought a suit against FX. Jennifer will correct me if I have the details wrong, but against FX and Ryan Murphy, the huge producer, with regard to a show called Feud, which was about this feud between Betty Davis and Joan Crawford. And Olivia de Havilland was featured in it, her real name, her real persona, but in a small role, and didn't say anything bad about her. But Olivia de Havilland brought suit to say that it violated her publicity rights, I believe. And this case was brought in California under state law. This case brings terror to the hearts of me as a producer of largely true stories, and brings terror into the hearts of my students. And could you talk about the case and this conflict, Jennifer?
Yeah, absolutely. So you got the description of the case exactly right. And I will mention that Olivia de Havilland thought, and she's recently died now, but Olivia de Havilland claimed that it was offensive to her, that it did negatively portray her. And for those who've seen it, you might recall various aspects of it.
How big a role did she have in this?
So yeah, so it was Catherine Zeta-Jones played the Olivia de Havilland character, and Olivia de Havilland, I gather accurately, was very good friends with Betty Davis. And so there were a couple scenes. There was a framing device as if there were a documentary at an Academy Awards that didn't take place. It was completely fictionalized, and Olivia de Havilland objected to a character, right, the Catherine Zeta-Jones portrayal of her as participating in such an interview, talking about other people, because she thought it portrayed her as a gossip. So that was a negative light to play her in. She mentioned some drinking by a fellow actor, which she also deemed gossipy. And then she referred to her sister as a bitch in a fictionalized phone conversation with Betty Davis, which she also thought painted her in a false light. So these things sort of overlap with defamation and false light. Ryan Murphy and the others involved in producing and writing it pointed to the fact that she called her sister a dragon lady and was always very critical of her sister. And so perhaps in a private conversation on the phone with a close friend, one might imagine her using such a term like bitch. And so is that really a problem or not? And so this
you
case
came down on the side of the First Amendment content creators, Ryan Murphy side.
Yes, so I filed an amicus brief at the appellate level, right, the second stage of the case, because the trial court had actually allowed her case to proceed, which did send terror in the hearts of producers' minds, because it called into question the ability to fictionalize things, to have new framing devices, to imagine dialogue, to portray real people in your movies, especially if they're still living. And the trial court had suggested that the case should proceed, that the First Amendment didn't protect this, in part because of a suggestion of false light, but also perhaps the most concerning, that possibility that she should be paid, that she, separate from any dignitary concerns, that she should get approximately $2 million for the reference to her as a secondary character played by another actor in this movie based on a true story. And that was deeply concerning. And so I organized some law professors to sign on to a brief that I co-authored with Eugene Bullock at UCLA. And and we filed it at the appellate level, and I was the lead counsel, and so I got to actually speak in front of the court, and there was a very powerful opinion from the California Appellate Court saying that this is protected by the First Amendment. These sorts of fictionalized devices are not asserted for the truth of the matter. They didn't paint her in a false light regardless. But also there's this claim that you get to control how you're portrayed in public, whether in newspapers or documentaries or fictionalized films or fictionalized novels, cannot withstand First Amendment scrutiny, and also potentially falls outside of state right of publicity laws. So very powerful. I will mention that on the opposite coast right now is litigation going on about another docudrama involving the Christopher Porco
Right.
story.
And the Lifetime movie,
Yeah.
which is also troubling, where an actual convicted murderer sued Lifetime and wanted money, I think, for a Lifetime movie depicting him. And he's won in the lower courts, I think.
Yeah, he hasn't won a final judgment, but the case is allowed to proceed, but it's currently on appeal. And
so first, yay, and thank you from all content creators for bringing that, filing that brief in the Olivia de Havilland case, $2 million. That's wild, and also that you couldn't even budget it, that you'd have to pay that retroactively, is so scary. So for all the content creators who are listening, there's California law, there's New York law. It's going to vary state by state, and there's privacy rights, publicity rights, defamation rights. What does a poor filmmaker do? How do they navigate this? I mean, other than, maybe park themselves in your office and ask your advice all day long, which I'm sure they will be doing after this, sending you emails. But what do they do?
Well, it is very complicated, and I think it's good to start there, in part because that if it's so complicated, it chills speech, it chills content, and particularly for people who are less well-financed. Even very sophisticated lawyers don't necessarily know which law applies, and then there's this question of whether rights survive death or not. New York just passed a law, just signed into law yesterday by Governor Cuomo, a postmortem right of publicity in New York, which
can you just stop 1 minute, Jennifer, and explain to the audience? So there's a right of publicity. Think about, say, Elvis Presley, but there's 50 states, and in some states that right is cut off when the second the person dies, and in other states it keeps going, and that's determined generally by where the person was when they dropped dead.
Usually, but not only. It gets more complicated because some states extend beyond what we call in law the domicile, right, where the person was a resident when they died. So Washington State, for example, Hawaii says if you sell things in our state, it doesn't matter where the person died or where they live, you can bring a claim. Those are very broad. Most states limit it to where you died. And then, of course, they could change, like New York, though it's not retroactive. And the duration of the statutes is different after death, right? So our hypothetical Elvis in different states, in Tennessee, Elvis gets to live forever under their statute. Unsurprisingly,
well, he should, yeah.
Right, in Tennessee. But in California, it is shorter, but still many years, I think 70 years, and was just amended 70 years. In New York now it's 40 years. Some states it's 10 years. It's in Indiana, it's 100 years. So very different. So how do you navigate this as a content creator? So a couple things. First of all, I want to highlight there are probably some people who are attending who like playing video games or might want to create video games. And I want to mention that if you are in the video game space, I would be somewhat more cautious, because those are largely the cases that are being lost, are the cases involving the use of real people in video games. Not across the board. Manuel Noriega, famous Panamanian dictator, lost his lawsuit against his inclusion in a video game, but student athletes who are included in the NCAA games by Electronic Arts succeeded in their lawsuit, in which a First Amendment defense was rejected. So I just want to, for the moment, put video games to the side. If you are creating, if you're working in newspapers, biographies, if you're working in the space of movies, plays, I think you're on much safer ground in terms of the likelihood that the First Amendment is going to insulate you from liability. I think Porco is really an outlier. I think it will hopefully be remedied at the appellate level. I think that New York has some idiosyncratic aspects of their law focused on the fact that they don't have a false light toward, and so it's sort of smushed into their right of publicity. And so when they think about whether a use is newsworthy or not, they say, well, if you fictionalized it, then it's not news reporting. And if you fictionalize someone's identity, you're doing it for commercial profit because you're not trying to just report the news. And so that gets it into this weird space. And then they don't have the anti-SLAPP mechanism there where you can get into court and say, this is a free speech issue early in litigation. So, but of course, if you're a content creator, you want to distribute in all the states. You don't want to have to navigate a problem in New York in particular, or Washington state. But I think when push comes to shove, if you're doing something in what's understood to be traditional media, that's a typical historical work, you're going to be on pretty safe ground. Now, this is their specific, so I'm not, just to be clear, not providing legal advice. There may be other ways in which people use a person's identity, for example, in marketing a film or a book that would be problematic, or the use of images. So I'm just putting that to the side. But generally speaking, people shouldn't panic if they're in the traditional realm. In video game space, I think that will get fixed over time. But the problem, I think, is that members of the judiciary are not generally video game players and are not generally educated in the way that video games can be like books today, that the history classes of the future might have students playing a video game about the Civil War, and maybe they would play different characters and reenact the battles, and that is a way of storytelling that is akin to a play or a book or movie.
So to reassure everyone in a very oversimplistic way, the more that your content is like news or documentary or more serious, more arty, the safer it's going to be. And the more that stodgy jurists, or that it looks too commercial, it looks more like advertisement, the thinner ice you skate on.
Yes, I think that in oversimplified terms, I'm a lawyer, so I'm also careful about these things, but that's certainly true. Like you don't want to be making bobblehead dolls or action figures of people to help market your film. That's right, going to be more dangerous than just telling the story. But there's certainly instances, it doesn't have to be historical. It doesn't have to be serious, as you say. We can imagine a movie like Forrest Gump, right, where there are lots of historical figures and it's not meant to be telling a true story, but it's meaningful that they're real people. That is relevant. If, on the other hand, you take a person's identity and basically you create a clip show that generates its value from the person's identity rather than telling a news story or even telling the story of that person's life, that will start to get more troublesome or more risky.
Jennifer, one of the cases I thought was really fascinating in your book was surrounded Vanna White, and she sued Samsung, who did this, what I thought seemed like a quite tongue-in-cheek ad where it showed robots, like I Machina robots. They didn't have her name, they didn't look like her, they looked like robots, and they're in a Wheel of Fortune kind of setting, flipping tiles, and she sued and won against Samsung. So in that case, is it because it's more commercial kind of content? Because that seemed like an oddball that she would win that.
Yeah, that is a very problematic decision, much reviled, certainly in legal academia. But in that, there was an ad campaign for Samsung's VCRs. And the notion was that the VCR would last so long that it would outlast Vanna White on Wheel of Fortune, which is funny. today, because of course the opposite is true.
Yeah.
And so they imagined a world in the future, which I think was 2020 maybe, that where Vanna White was replaced by a robot. And so they had a robot with a blonde wig that didn't look anything like Vanna White. It looked like a robot. Nevertheless, she won a right of publicity claim because it was deemed to evoke or conjure up her identity and to be a commercial advertisement that profited from that association with her identity. So I think you're right. If that had happened in a movie or a book or a TV show, may not have come out in her favor. Still problematic in the context of an advertising, because it was, as you say, sort of a tongue-in-cheek comment. It didn't actually use her identity. And it opened the door to a much broader, more capacious right of publicity claim. So of particular relevance to the film industry, it set up a lawsuit by George Wendt and John Ratzenberger, two actors from the long-running Cheers sitcom, in which Paramount Pictures licensed to Host International, the company that does those airport restaurants and bars, the Cheers set and the characters Norm and Cliff. And then Host, right, wanted to set up these Cheers bars, which some of you may have no idea what the Cheers show is at this point, but it was supposed to be a bar where people knew you and were comfortable with you. And the actors, and so they set up these robots, and the robots were supposed to make you feel comfortable when you're away from home. The actors who had played Norm and Cliff on the show sued, claiming that the robots, which didn't look like them, evoked their images in the same way that the robot evoked Vanna White. And they too proceeded on the basis essentially of the Samsung, the White v. Samsung case, and got a settlement. I don't know exactly how much the settlement was, but they got through the first round of litigation and then got a settlement. So certainly when you think about TV shows or films or even video games where using even actors, you have to think about how might you want to market the content and the characters after the fact, and what permission have you gotten from the actors to do so?
So, I mean, we could talk about scripted and documentary content all evening, but shifting gears a little bit, with the rise of social media and TikTok stars and Instagram stars, how has that influenced or been influenced by the right of publicity, and how should our students and viewers think about that and protect themselves when they're putting themselves out on social media?
Yeah, that's a great question. And I think one thing that I meant to say in my initial comments, but didn't, is that this new world of social media has really broken down the distinction between public and private figures, between public and private spaces, which makes this artificial divide between the right of privacy and the right of publicity particularly absurd, and also means that the right of publicity could be a valuable tool in reining in some of the rampant unauthorized uses of people's identities online, from like revenge porn and deep fakes. May have something to say about that, and be a tool for reining some of that in. On the other hand, there are very complicated questions in social media. Ariana Grande is sued, Forever 21 over some Instagram campaigns. Katherine Heigl sued Dwayne Reed over posting a sort of image of her shopping at Dwayne Reed and carrying their bags. People have sued for retweets of things they've done that might show, hey, that's our handbag. Or, oh, if you like this ring, Reese Witherspoon has sued, right? If you like this ring, we sell a ring just like it. Look, Reese Witherspoon is wearing it. When is that okay? Just describing what people are wearing on the red carpet. When is it violating well-known people's identities? On the flip side, right, we think about just live streaming or posting things of regular people online, things they may not want to see. The famous, I don't know how famous, but some of you may know the Plane Bay experience, where someone was sort of having a flirty conversation with someone on the plane, and the entirety of it was live streamed on Facebook, and causing this woman great shame, and then people were targeting her. And so sometimes the question isn't what could the right of publicity or the law do to address that, and more what can each of us do to address it. So I like to ask people to think about what they would want others to do. and think about, would you feel comfortable asking the person's permission? Is it a circumstance where you could ask permission? And why are you not asking? So you could ask before you post, you can ask before you film, and there are instances where you don't want to. If there's an instance of police abuse or overt racism, you might want to record it and share it. It may be that it's a documentary and you're trying to document something and sort of stay out of it. But if you're just filming people's lives and trying to put it up, I think that as an ethical matter, it's often better to err on the side of asking people whether they're comfortable having their images and videos circulated.
Right.
Can I ask Jennifer a question? One of the questions from the audience came in about the result of the Olivia de Havilland case. Could you just let us know what that happened?
Yeah, so on appeal, which was the part where I and some other intellectual property and constitutional law scholars filed an amicus brief, and there were also, of course, lawyers who did a great job for the defendants at effects. The appellate court upheld they reversed, and they protected the filmmakers and producers from liability for de Havilland's claim. It was a very powerful free speech case that says, the First Amendment protects books, plays, movies about real people, and you can't claim that you have to be paid every time someone mentions you.
And I have one more quick question since I didn't get to ask one. So my question is about something like The Crown. And what is the story in England? How are their rights different? Because The Crown really drills down into the royal family, both living and dead. And I know there's been a little bit of controversy from the palace saying, yeah, you guys should have said that this was fictional. So what's the difference in England?
Yeah, so England doesn't have the same sort of right of publicity that we have here. There was a fair amount of litigation after Princess Diana died and the commercialization of her identity, and there's no postmortem rights certainly there. And so she, her estate wasn't able to stop uses of her identity, certainly in the US. But I think that the Crown raises some of the same issues as it does in the US, which is that you get to tell real stories about people, but, and this is where creators need to be careful, you can't defame people or paint them in a false light. So if you are saying things that aren't true about people, you need to be careful about that. Does it negatively portray them? Is it asserted to be truthful? And I think that's why we see a lot of disclaimers at the beginning and end of things saying there's fictionalization, some of the characters are created. But but one of the things that's so wonderful about the de Havilland decision is it emphasizes this latitude of fictionalization, which is that we anticipate that even if something's based on fact, even in a biography, even in a straightforward biography, the author, a good biographer, is going to try to imagine some dialogue or what the people might have been thinking. They need to have some artistic license to do that. And people don't expect, audience members don't expect that they know what people said in a private phone conversation. So if you're going to dramatize those sorts of historical things, you're going to have some latitude to imagine what they might have talked about. And I think that's true for The Crown as well. If you go too far, you may have trouble.
Right. I think the creator, Peter Morgan, basically said, we are trying to get to the spirit of the conversations. We don't know exactly what was said, but we are trying to get to the spirit of it. And I think that that's what you're talking about. So, so I think we're at the end of our evening. That was lovely, fascinating. Both you guys, I could sit here for days listening to you talk. And I would love to hear more about these cases. So maybe we'll have to have another pub night for this. And I really appreciate you both coming. And please come again and talk with us. And for the management students or the business students, I need to share my screen and give them a QR code, which I'm going to do now. So there it is for them. And as I finish off, I just want to thank all of you for joining us for this evening. And we always like to thank our Dean, Christine Brancolini. She is always supportive of the Hannon Library's fabulous programming, and we thank her. I hope you will join us next month on Tuesday, January 17th at 5 p.m. when we will feature Dr. Aidan Namin and his co-authors, who will be discussing their article, Dine In or Take Out, Modeling Millennials' Cooking Motivation and Choice. So it'll be quite a different evening, but we hope you'll join us. And finally, please take time to fill out the very short survey that will pop up once you leave the program, as it will help us plan and improve our future programming. So thank you all again very much, and we will hope to see some of you next month. Thanks again, Jennifer. Thank you, Roseanne.
Thank you
Thank
so
you,
much.
everybody.
Having us.
Have a good night.